Ending relationships. In this section, we'll discuss separation, annulment, and dissolution as possibilities toward ending a relationship in California. Separation can be done in two ways, either formal legal separation or informal separation. Formal separation is a substitute for divorce. You divide the property, the debts, the custody, and the spousal support without doing the actual divorce paperwork. Why would you do this? Well, a couple different reasons. Some people believe that for religious reasons they cannot actually get divorced, quote unquote, but they're not able to continue living with their partner and continue to be happy. And so, for religious reasons, they would choose a formal separation. Secondly, sometimes you have one spouse who has insurance or medical care which the second spouse benefits from, and even though they agree that they can no longer live together as a married couple, they do want to be able to continue to take care of each other in terms of providing these continued medical care or insurance benefits. Informal separation happens in one of two steps. It can either be a trial separation or permanent separation. A trial separation is just a test period where the couple lives apart and decides whether or not they want to continue the relationship. Any assets and debts accumulated during this time are community property. If the couple decides that they are not going to be able to work things out and they need to split up for good, then that would be a permanent situation. They've made the decision that this is no longer a trial period, they are going to split up for good, and in this situation, any assets or debts which happen after the permanent separation is decided upon will be separate property unless there's a court order for the spouses to either split it or for it to go to a specific spouse. Annulment is another way to end a relationship under California law. It is a legal proceeding to end a marriage by treating it like it never happened. You may have heard of annulments before in a religious context. In certain religious establishments, there is an annulment process by which the particular church or religious organization will treat the marriage as if it never happened for religious purposes. That type of annulment is specific to different religious organizations, and you can ask them specifically what the rules are for those. This particular annulment is a legal annulment under state law, and it works a little differently. It's a legal proceeding, so instead of a religious proceeding, but it also treats the marriage like it never happened. You would fill out the same forms as you would if you're filing for divorce. The children are treated the same as children of the divorce. In other words, you would go through a custody procedure and different court procedures in order to divide that up. And the defrauding spouse may get less than 50% when everything is broken up because of the fraud. A marriage may be annulled in two situations. Number one would be a lack of capacity. In other words, you're arguing that the person who entered into the marriage could not have legally done so. For example, they could be under the age of 18 and not have gotten that parent or guardian permission and signed off by the judge, which is required for marriage. Secondly, the spouse could have been 5 years missing or presumed dead, and they've shown up, but the other spouse has actually remarried. In this instance, you can annul or file to annul the second marriage. And thirdly, unsound mind. And so we're looking at, if you remember when we talked about the elements of marriage and the requirements for marriage, you have to be not married. And so if you were married and you choose to get married again because you think that your spouse is either missing or is presumed to be dead, then the second marriage cannot legally happen because the first marriage is still in force if that person shows up. Same thing with unsound mind. If the person lacks the capacity or lacks the sanity to actually go into a marriage and make a competent decision to be married, then you can annul the marriage. Secondly, a marriage may be annulled due to mistake or inadvertence. In other words, something went on between the spouses to make it so that if the spouses had both known about a situation, they would not have entered into the marriage in the first place. The biggest thing we're looking at here is fraud. So spouse 1 told spouse number 2 something which spouse number 2 relied upon in order to make a decision to marry them, and that thing was significant enough that if they had known about that, they would not have married them in the first place. This is similar to, well, not quite similar to, but coercion, for example. Coercion is when you're being forced to marry somebody. So you didn't mean to marry them, but perhaps the spouse number 2 was told something, like if they did not marry spouse number 1, there was a threat upon their family, for example. That would be coercion. A third thing would be the spouse is incapable of having children and the condition appears to be incurable. And this is a situation where the two, spouse 1 and spouse 2, not having known until their ability to consummate the marriage whether both parties were able to actually have children, go ahead and get married, and then one spouse turns out to be to not be capable of producing children. And since it has been shown, legislated to be public policy over the years that marriage is entered into for the purpose of creating children, this is something which it is on the books that you can annul a marriage if the spouse is incapable of having children, and there doesn't really seem to be anything that spouse can do about it. Third, we have divorce. In California, divorce is actually called dissolution of the marriage. And so if you see forms for dissolution and you're looking for divorce forms, you're in the right place. They actually don't say divorce on them, so take a look for that specific word, dissolution. What dissolution is it's a legal procedure which is necessary to end a marriage or a registered domestic partnership. The basis in California is irreconcilable differences or incurable insanity of one spouse. In other words, California is a no-fault state. Nobody has to show that somebody did something wrong. You don't get any bonus points for being the spouse who didn't quote-unquote do something wrong. All that has to be shown is that there are differences between the spouses that can't be reconciled, or one of the spouses has suffered insanity, which is incurable, and so they're no longer able to be married. One spouse lives in California for 6.5 months, and in the county for 3.5 months immediately before filing, or the registered domestic partners can divorce even if they have moved out of state. So we're actually looking here at a rule where married couples actually have a greater restriction on whether or not they can divorce than registered domestic partners. With married couples, at least one spouse must live in California for 6 months and in the county that they seek the divorce in at least 3 months before filing. However, if you're a registered domestic partner, you do not have to meet this requirement, and you can seek a divorce in California even if you have moved out of state. Dissolution comes in 2 types, a summary dissolution and a regular dissolution. A summary dissolution, the pros to this is that there's very little paperwork. You don't actually have to go to court, and the divorce is final 6 months after filing. So it's a very, very quick dissolution. The cons are that they must sign a property agreement and give up the right to seek spousal report. And there's no appeal after the decision to divorce is finalized. So this is a good idea for couples who maybe have no property, have no children, they don't need spousal support from each other, and there's very little to divide up. So this can be done quite quickly and without much hassle, and most people like it because they don't have to go to court or go through a lot of heavily nuanced filings. In order to be eligible for summary dissolution, you must meet certain criteria. Number 1, you must be married or registered as a domestic partner for less than 5 years, actually 5 years or less. You have to have no children and not be expecting at the time. You have to own no real estate that would have to be divided up. You have to have less than $4,000 in community debts, which does not include cars. and less than $25,000 of community property assets, which also don't include cars. And you have to have less than $25,000 separate property, which also does not include cars. Regular dissolution is a little different. The pros of regular dissolution is that it may be able to be processed by mail if there's an agreement on how to divide the property. The cons to this is that it can only be finalized 6 months after the second spouse was served. So depending on finding the spouse, how long it takes to get the service completed, this may delay the process. And additionally, there is lots of paperwork involved, which must be completed before service, of course. And it may require a court appearance, especially if there is no agreement on how to divide the property. Then the court may have to determine how the property is divided through an appearance. Couples can divide property any way they like as long as they agree. If they don't agree, that's when the judge steps in. That's when the court comes in and divides the property. Usually this is the way it works. The separate property is going to go to the spouse who owns it, and the community property is going to be split equally. That's generally where the judge is going to go. So if the couple wants this to happen in another way, it's a good idea for the couple to actually make an agreement that they want to have enforced of how they're going to separate their property out. Like I said, they can separate it out any way that they believe is fair between themselves. And if they don't want to go with kind of the general rule here of what a judge would do, this is a good idea for them. Children may not be taken out of state without written permission from the other spouse and the court during this time. So once the divorce is filed, once they start into this process, then children can't be taken out of the state without written permission. And oftentimes that specific request for dissolution is going to have that written into the order. Sometimes you'll have a situation where spousal support, also called alimony, is requested by one side or another. Alimony is a series of payments made to one spouse or partner by the other for a specified period of time after a divorce. The idea here is that you have one spouse or partner who is unable to care for themselves financially because of the way that the marriage has been run in the past. The court will consider several different things. Actually, the court will consider a lot of different things. And because of this, it's important to understand that there actually is not a lot of spousal support which is awarded by the courts because there's such a steep bar to meet. The court is going to consider the age and health of each spouse, the earning capacity to support the standard of living established during marriage. And so if only one person, for example, is capable of earning the big bucks, but they were used to living quite an elegant and opulent lifestyle, then the court will take that into consideration. The supported spouse's marketable skills will also be looked at. Is this person able to, with their age, with their health, with their skills, able to go out and actually get a job which is going to support them? The court will look on limitations on the supported spouse's employability and the contribution of the spouse to educating, training, or the career of the other spouse. The court will look at actual financial needs of the spouse who's seeking support and the ability of the supporting spouse to pay for the supported spouse. The court will also consider the obligations and assets of each spouse, the duration of the marriage. There is a presumption that support is appropriate if the couple has been married for over 10 years, although it's a good idea for the supported spouse to go through each of these different pieces to show the judge that even without this presumption, they should be entitled to spousal support. The court will look at the ability of the supported spouse to work without an adverse effect on the children. So if the supported spouse was a stay-at-home mom, for example, the court will look at whether or not mom going back to work will have an adverse effect on the children she used to stay home with. The court will also look at tax consequences and the goal that the supported spouse will be self-supporting within a reasonable period of time. It's important to remember that spousal support is not indefinite. It's just for a reasonable period of time after the divorce. The court will look at documented evidence of domestic violence or a criminal conviction of abuse, and will also look at child support payments. Tax rules. The supporting spouse will get a tax deduction for the amount paid. The supported spouse, on the other hand, is going to use that amount received as taxable income. And so this could have an extreme effect on how taxes are reported between the spouses. Now, the reason I have IRS in parentheses at the bottom there is because, again, you have to remember every time we're dealing with taxes, you have to think about federal taxes. And so this is going to affect a married couple who is divorced, or a married couple who is in this situation. However, registered domestic partners who are seeking a divorce, this would not necessarily be true because the IRS would not have registered their marriage as a marriage, and so they wouldn't necessarily have the same tax implication. There are ways to modify spousal support. The court order while spousal support is there could modify by a court order while the spousal support order is in effect. So if the couple does not like the spousal support order, or one does not like the spousal support order, they can go and seek a court order to modify that specific order and change it. Because of this, the court may retain jurisdiction indefinitely for marriages lasting more than 10 years to make sure that they can always come back to modify the spousal support order if needs be. Modification can also be sought for material change in circumstances. For example, the ability to pay has increased, and so the supporting spouse, who perhaps before could not afford to pay to support the supported spouse, might have a change in circumstances in that now they have a new job which has increased their ability to pay. Additionally, the need for the supported spouse may have decreased. There's a presumption that if the supported spouse is now living with somebody new of the opposite sex, that they're actually getting some sort of benefit from that, and their need for spousal support has decreased. Of course, this is a rebuttable presumption, and the supported spouse can make an argument against this, but a modification can be sought on that purpose as well. Support ends when the order ends, or when the recipient remarries or dies. Lastly, we have just a note on domestic violence, in that the most powerful tool to stop domestic violence is a temporary restraining order, and this may be something which is needed to put the fast brakes on a relationship that is going in a very dangerous direction. A domestic violence temporary restraining order is a decree from the court which is tailored to the particular circumstances of the relationship, requiring the perpetrator to stop the abuse. There must be evidence of the abuse. This can be shown in a police report. This can be shown in doctor's reports, for example, or a criminal protective order, police protective order. Domestic violence restraining orders can be issued against a spouse or a former spouse or domestic partner, a cohabitant or former cohabitant, that means someone you live with or used to live with, an adult blood relative, or a boyfriend, girlfriend, fiance, or an ex-fiance, ex-girlfriend, or ex-boyfriend. So pretty much if you are in or were in a relationship with somebody and you suffer domestic violence at their hands, then you are eligible to apply for a temporary restraining order.